Welcome to the Employer's Defense Podcast.
Hello and welcome to the Employer Defense Podcast with experienced attorney Clifton Smith. I am your host, Kevin Rosenquist, and today we're going to discuss effective defense tactics for wrongful termination claims. Clifton, great to see you again.
Great to see you.
All right, so let's start out talking about what actually constitutes wrongful termination and why it's a significant issue for employers.
All right, let me start by saying that this podcast will benefit California-based employers specifically, which is where my practice is located, but may also be of general benefit to employers outside the state. So let's start by talking about what wrongful termination is not. I brought with me a jury instruction, casing number 2400 on breach of employment contract, discussing the at-will employment relationship in California. And it says an employment relationship may be ended by either the employer or the employee at any time for any lawful reason or for no reason. That's called at-will employment. And so that's the standard in California that we start with. This is an employment at-will state, which means that either side can end the relationship at any time for any reason as long as it's not an unlawful reason. And then that brings us to wrongful termination. And typically in this state, what you see is a termination that either follows some other kind of unlawful conduct or is, if you will, an excuse for wrongful termination. So, for example, let's say the employee complains to the employer or even to a state or federal agency about what the employee believes is wrongful conduct by the employer or illegal conduct by the employer. And the employer's response is to terminate that employee. There are California Labor Code sections that prevent that kind of action. It's considered a form of wrongful retaliation. Another example would arise under FEHA, which stands for the Fair Employment Housing Act, which prevents discrimination in employment based on age, sex, national origin, religion, veteran status, marital status, etc. If the termination is alleged to be part and parcel of some type of action that relates to discrimination or following a complaint of harassment, that would also be another form of wrongful termination. And I would say in my practice, these are the types of wrongful termination claims that typically arise.
What key laws and regulations do employers need to be aware of when it comes to wrongful termination?
Probably the laws I just mentioned. One, the FEHA, Fair Employment Housing Act. You must be aware of that law in the state of California. Again, its requirements and its standards are higher than its federal counterpart. You have to, again, be familiar with the labor code and understand that you just can't immediately react to an employee who complains about you and necessarily let them go simply because they voiced a complaint. It may actually run afoul of the labor code, and you could be accused of wrongful termination because of that. These are instances where you need the guidance of an attorney.
What can employers do to kind of help prevent any sort of wrongful termination potential? Like they might see something as a justified termination, but if there's a chance that the employee could see it another way, is there anything they can do to help protect themselves from a suit?
The employee always sees it the other way.
Good point.
Again, I can't overemphasize the importance of policies, procedures, handbook, written rules and regulations, rules of the road that advise every employee of what conduct is prohibited. I've yet to see a handbook that doesn't include conduct that could result in discipline to and including termination. And you want to make certain at the outset of an employment relationship that each employee receives, reviews, and signs for receipt of their employee handbook containing all these rules and regulations, because it is going to be their roadmap and it's going to be your roadmap too. So the foundation to all of this is good policies, procedures, handbook, written rules that the employer can rely on. Second point here is it's important that you provide training to your management team. Don't just hand them the handbook and say, here, read this. You need to walk them through, and you need to pick the right people to be on your management team. Just because Bob made great widgets, that doesn't mean that Bob's going to be a great supervisor. The skill set that's required is completely different for supervision and management than it is to directly manufacture or provide, a product or provide a service. So you want to make sure that all those basics are in place. And then you want to make sure that you take an orderly approach to enforce your rules and regulations. And what I mean by that is you have to document. If you have a problem with an employee, you have to document the issue that you're trying to address. And you want to try and correct that performance where appropriate. So that's where a PIP comes in, for example. A PIP stands for a performance improvement plan. Often in lieu of discipline, progressive discipline, an employer will use a performance improvement plan to let the employee know specifically what is expected and what must be completed for the employee to retain their job. And that can be a very effective tool either to correct the performance or to get rid of the employee if the performance is not corrected while protecting yourself in the process. And any trier of fact, they're going to look to your records again. And so it's important that you document what you're doing and why you're doing it. And if you use a PIP, that's a great way to do it. Otherwise, you want to use progressive discipline. In most instances, you can document the misconduct in question and try to get the employee to address it and resolve it by handing them a warning. There will be those instances, though, where progressive discipline is not going to be appropriate. You're going to let them go for the violation because it's so egregious. Maybe it's falsification of records. Maybe it's theft. Maybe it's sexual harassment. In those instances, you're not going to give them a second chance to steal from you or harass your employees. You're going to send them down the road. But you still want to document that, again, so they know clearly why they're leaving, what they did wrong. But equally important is to protect you, the employer.
Yeah, you bring up a good point, because I've heard a lot of situations before and talking to people where it's like, if they're a small company or they're just like, a bunch of young people who all are just kind of like, loose with things, and it's not real regimented, that they avoid documenting the smaller things or even the medium-sized things, and then they get into trouble down the road. How important is it to document everything?
I think you can overdo it at one extreme. You don't want to document, quote unquote, everything, but you clearly want to document conduct that you find unacceptable. So, if the employee says to you, uses profanity to communicate with you, that's not acceptable. And then it's your decision whether you want to merely issue a warning or maybe even send that employee home on a suspension, depending on what was said and the extent of the profanity that was used. But either way you do it, you want to make it crystal clear to the employee that is a form of harassment that will not be tolerated. It's a form of misconduct that must be corrected. And you want to put it all in writing, because I guarantee you this same employee is going to bring other issues to your table that will have to be addressed. And the likelihood is you're going to be sending that employee down the road. And it's just a question of when, not if. And so you want to have a clear paper trail showing that you tried to correct the behavior and it could not be corrected. And that protects you in litigation, because it lets everybody see that you tried to be fair, that you tried to be even-handed, that you tried to address the behavior. And let's face it, sometimes you just can't correct the behavior. People just don't get it. And in those instances, they have to be given the opportunity to seek employment elsewhere. They're going to cost you money. If they're talking to you like that, imagine what they're saying to their coworkers.
Or customers.
You're absolutely right.
Yeah, good point. Can you outline sort of the typical process for defending an employer against a wrongful termination claim?
Yes. Again, it starts with the conversation with the employer, the initial conversation. As part of that, I usually want to look at the lawsuit before our first conversation occurs, so I can understand specifically what is alleged. And that can better inform my interview with the employer. And that can also help me frame questions that I want to ask the employer. They'll help me better understand the allegations as well as the defense to that. And then what we want to do, again, we're always under a timeline in litigation. You only have 30 days to answer a complaint, or perhaps even less than that to respond to a state or federal claim. And so those things have to be completed in a timely manner. We want to gather our evidence. We want to get evidence from the other side. Of course, we want to conduct depositions when possible to test the plaintiff's ability to tell the truth and represent the case. We want to formulate our own defenses as well based on that. We want to evaluate early exit strategies such as alternative dispute resolution, mediation, things like that, arbitration, anything to get this matter resolved before it goes before a jury.
Can you talk about the process of mediation or arbitration and how it relates to this?
Mediation is typically used. I haven't seen arbitration in some time, except for where you have an arbitration based on an arbitration agreement that the employer has. So let's talk about mediation first. So we have entire companies out there now that offer private mediation services. And so typically what happens is the parties, counsel for the parties, agree on a specific mediator. And then you basically now you go into a remote Zoom conference to engage in mediation. The process itself has become pretty painless. You don't have to drive anywhere. You just simply get on the computer like we're doing now with your client, and both sides have an opportunity to work with a mediator to seek a resolution. Mediators get paid to resolve these cases, and some take great pride in getting them resolved. And so mediation becomes a very effective way of getting the case eliminated to resolve the case. But, typically the employer is going to have to bring their paycheck or bring their checkbook and be ready to pay a certain sum of money to make the matter go away. But typically in mediation, you're going to get a pretty cost-effective result. That mediator is working for both sides. I've been able to get great results for my clients in mediation. Now, arbitration, in contrast, is more of an expedited trial, but it's in front of an individual fact finder who might be a retired judge, could even be a retired attorney or one that's actively practicing, but they're acting as a mediator. And that person decides what discovery, if any, is going to be allowed and is going to put the case on a fast track for resolution. So it isn't going to go for 2 or 3 years. It's going to be resolved within 6 months. And it's a much quicker way to get the dispute resolved. It streamlines everything, which cuts costs, but you have to be prepared to go.
How often does it go beyond that? How often does it actually go to a trial, something specifically to wrongful termination claims?
Seldom.
Yeah.
Most of these cases get resolved before trial. But there are a few where the parties just cannot come together and the reasons, there's just a myriad of reasons why. It happens, but I'm going to say in fewer than 10% of the cases, by and large, 90% of these cases get resolved before trial.
Is there any data that you have that if it does go to trial that, might say, the trials generally benefit the employees or generally benefit the employers? Are there any sort of I don't know, is there a lean?
I would suggest that the results are all over the place. There's no trend line. And again, it depends on where are you? If you're in LA, the odds are the employee is going to have a better forum in Los Angeles than the employee might have in Orange County, for example, or San Diego. It really depends a lot on where the litigation is going to be tried. Mm-hmm. Geography plays a very important part. And so you really just, the demographics, you just don't know what you're getting. When you take a look at that jury room and see who's there that's about to go and be, ordered, it can become kind of a scary prospect for an employer. You start looking at people that are going to decide your case, and you really don't want to be there if you can avoid it.
Yeah, we've talked about it because the public perception is often, against the employer and, supporting the employees, between, movies and TV and all that stuff. Usually it's about when an employee is wrong. You don't see too many about when an employer is wrong. So typically speaking, did you find that juries would relate to the employee more than the employer?
Well, that's my belief. You're trying to screen that out when you're picking a jury, but
sure.
Good luck with that.
How important is proper documentation in defending against a wrongful termination claim? We talked about documentation earlier, but how important is it to have all of your ducks in a row when you go into this, when you start talking, when someone sits down to talk to you?
Oh, it's critical. The documentation supports your theory of the case, supports your account of what occurred. If you can show progressive discipline or a performance improvement plan over time, some record demonstrating that you tried to correct the behavior over time before the termination occurred, the defense will be strong because it explains why this was not a termination for discrimination, somehow related to discrimination based on sex or some other improper category. It was not retaliation for the employee's complaint that the employer was allegedly involved in unlawful behavior etc. Having that documentation, having that paper trail is there for the employer's protection. You absolutely want to have it in place. Now, having said that, sometimes, as I said, you have instances where there won't be any progressive discipline. There won't be a performance improvement plan. You're just going to have to let the employee go because the behavior in question was egregious and they can't remain. It's not a safe situation. It doesn't protect the employer and it doesn't protect fellow employees. You've got to get them out.
Well, obviously, disciplinary records, things like that are super important to keep. When it comes to something like a performance evaluation, I mean, some companies do them, some companies don't. In your opinion, as an attorney, what role do performance evaluations play in defending against wrongful termination allegations?
I have seen these performance evaluation forms, and I've got to tell you, most of the performance evaluation forms I see are absolutely useless. They're 2 or 3 pages long. They've got 25 different categories. They've got 5 different boxes you can check for 6 different questions under each of the 25 categories. And the reality is the supervisor who's never been trained to even do a performance evaluation is going through checking all the boxes in the middle or, saying, outstanding, excellent, beyond reproach. And then guess what? You got to let the guy go because he sexually harassed Sally, or because the guy has caused tens of thousands of dollars in rejects of product, but yet you rated his quality as outstanding. How does that help you?
So would you say almost it's more of a detriment than a help as a general rule?
I think it's a complete washout. I think what employees view a performance evaluation as an indication whether or not they're going to get a raise.
Yes, that's true. That's true.
Most performance evaluations, there's nothing in them that says, and for this, you're going to get a raise. It's just a performance evaluation. And yet when you give one to an employee, you've created an expectation of increased compensation. And you need to keep in mind what you're doing. I know that most employers think that this is the way they hand out attagirls or attaboys to their employees and, make them feel good about what they're doing. And that's important. But these forms, they don't help the employer at all.
That's interesting. I guess I never thought of it that way, but you're right. It's mostly about people assuming that they're going to get compensated if they have a good one. Well, thanks for tuning into the Employer Defense Podcast with experienced attorney Clifton Smith. For more information or to connect with Clifton, you can visit cesmithlaborlaw.com and be sure to hit that like and subscribe button and leave us a review in the comments. Clifton, great to see you. Thanks for all the insight.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.